I've had a number of people ask me to conduct a short course for them on probate and on how to avoid probate. And I thought today would be a good day to do that. So let's focus on this whole business of probate and how to avoid it. Let me define it first, and I say this somewhat humorously. I have a good friend who's a business partner of mine, a friend named Peter Parenti, who lives down in San Antonio, Texas, and he defines probate this way. He says it's a lawsuit that you file against yourself with your money for the benefit of your creditors and your disgruntled heirs. I think that that sums up what I view as the disadvantages of probate pretty well. So, but let's think for a minute. How does property pass when you die? I think there's a lot of misunderstanding about that, but I'm going to cause the fog to lift on that for you here in the next few minutes, because we're going to take a look at all the different kinds of property and how that property does pass when you die. And I've created a little animated graphic to illustrate the concept. So let me say first of all that there really are only 4 categories of property to think about. There is property that you own that is joint, and I want to say, when I say joint, I mean joint tenants with right of survivorship. There is property that's held in trust, and thirdly, there's property that passes by beneficiary designation. And by that, I mean things like IRA accounts, things like life insurance policies, annuities. It's also possible to do bank accounts this way using what we call a pay on death or POD designation on the account. Those are all that falls into what we would call a beneficiary designation, assets that pass by beneficiary designation. And then we have other property. There's no other kind of property out there. Every kind of property that exists is going to fit into one of those 4 boxes, right? So what happens whenever I die? How does that property pass? Well, the first 3 categories, the property that is joint passes to the surviving joint tenant, but doesn't go through probate. Now, there's another video here on our website where I talk about the hidden dangers of jointly owned property, but it is true that if there is jointly owned property owned jointly with right of survivorship, it does pass without probate to the surviving owners. A lot of reasons not to have joint property, but in this case, that we treat that as a non-probate asset. Assets that are held in the name of a trust also pass outside of the probate process. Assets that pass by beneficiary designation also pass outside the probate process. But the other assets have to go through probate, and that means that they pass by will if you have a will, and if you did not have a will, it means that they still go through probate, but who receives that property is determined under state law, under what we call the intestacy statute. That's property. That means if you die without a will, you died intestate, and the property that you have that passes through probate goes to the individuals that the state statute designates. If you have a will, the property that passes through the will is going to go to the persons that you named as the beneficiaries under your will. If you go through probate, one thing I want to point out is that there is some expense associated with it. You can see here that this is what you see on the screen here is what the Arkansas Code annotated provides as the fees that can be paid to the personal representative for being the executor or the administrator of the estate, and the fees that can be paid to the attorney for being the attorney for the estate. And these are all fees that can be that a court is authorized to approve without any special hearing to show how much time, work, or effort the personal representative or the attorney put into it. But it is still rather expensive. So I've said that if you die without a will, that's called dying intestate, and that means that all the assets that are solely in your name that don't pass in one of those other 3 ways are going to go through probate, which means that there's no privacy. It's expensive. You saw what the fee schedule looks like. It's going to take 9 months to a year or longer typically to move these assets through the probate process, and because you didn't make a will, you have no choice over who inherits them. Who inherits them is determined by the state legislature, and it's all set out in the Arkansas Code. Now, if you make a will, a lot of people make wills thinking that by making the will they avoid the probate process. That is actually not true. If you have property that passes under your will, that property actually does have to go through the probate process. That's why we say that a will doesn't avoid probate. A will actually guarantees probate. And once again, there's no privacy, because everything in that probate file is there at the courthouse in a file, and it can be looked at and copied by anybody who's interested enough to go down to the courthouse and take a look at it. It's expensive. We pointed that out. You saw what the fees were. And once again, it takes 9 months to a year or more for this matter to work its way through the probate process. Now, I want to speak for a second about a common misunderstanding I think is unfortunate, and that is the belief that if you made a will, that will controls the distribution of all of your property. Fact is, it doesn't. You remember the little animation I did a while ago that showed that joint property passes outside of the probate process, property in a trust passes outside the probate process, property by beneficiary designation passes outside the probate process. And what I'm saying to you is that if you made a will and you have property that passes by beneficiary designation, or property that's titled jointly in your name and somebody else's name with right of survivorship, that property is not going to pass under your will. Now, that's not a bad thing. It's only a bad thing if you thought it did. And I have a lot of clients who come in and I'll ask questions like, well, who gets your life insurance? And they'll say, well, you know, my will says, and they start to tell me what the will says, and I have to stop them and say, in this case, it doesn't matter what your will says. That life insurance is going to pass by beneficiary designation, and that life insurance company doesn't really care what your will says. Or sometimes they'll say, you know, my will says this, and I'll say, but that property that I'm talking about here is jointly owned with you and 3 other people. And they didn't realize that when they made their will, they didn't override all that and cause that property to now pass under the will. So I think it's very important to understand that if you have a will-based plan, that will only controls a certain portion of your property, and quite often the portion that it controls represents a fairly small portion of your total estate. If a big part of your estate is comprised of an IRA account, for example, and that's the case with a lot of people that we see, the IRA account is not going to pass under your will. You know, down at the brokerage house or the bank where you have your IRA, they have a beneficiary designation form, and you've written somebody's name in there to say who gets that account. It doesn't matter what your will says, because when you die, that account is going to pass to the person or persons that you named in the beneficiary designation. Same thing for all your life insurance or annuities. So I just want to dispel this myth that somehow when you make a will, you've magically reformed all of your beneficiary forms and you've taken away all the joint ownership, and now everything you have is going to pass under the will, and that's simply not the case. Now, I mentioned that if you have a will plan, you eliminate any sense of privacy over your affairs, and that's because when your will is filed, there's a file opened up in the probate clerk's office. The will is there, the summary of all the assets that you have are there, all the debts that you owe are there, and all of that is available for public inspection during business hours when the courthouse is open to anybody that wants to come in and take a look at the file and even make copies of what's there. And so many of you recognize this guy, Mr. James Gandolfini. You know, he was the guy that that was very popular in the television series, who died a year or so ago. We know that he had a $7 million life insurance policy that he left to his son. We know that he bequeathed 2 nieces $500,000 apiece. We know that his godson got $100,000. We know that $200,000 went to a close friend. He left an equal amount to his assistant. We also knew what the debts were in his estate. We knew what his total estate was worth, all of those things. And how did we know that? We knew all of that because He had a will plan, and when he died, his will was filed in the probate clerk's office there in New Jersey, and a summary of his assets were filed, a list of all of his debts, other obligations, that was also filed. And so anybody who went down to the courthouse could check that out, and a lot of people did, and all this information got out on the internet, and so all of us know exactly what he had and what he left and who he left it to. Now, in my view, the best way to avoid all of these issues, to avoid the problem with having everything made public, to avoid the delay, to avoid the cost, all of that, the best way to avoid all of the problems of probate, and also the best way to coordinate the distribution of all of your assets, not just the assets that would otherwise pass under a will, but all the assets that you have that would pass by beneficiary designation, the assets that would pass as a result of this joint tenancy with right of survivorship. The best way to solve the problem and to simplify and coordinate all of that is to create a revocable living trust. Because with a revocable living trust that is properly funded, all of the problems that I've been talking about relating to probate and the unintended consequences of joint ownership and having a plan that's uncoordinated, we're able to solve all that. Here's an example of a guy who did solve all that. Steve Jobs died a couple years ago, and Forbes magazine says, we have no idea who got his estate because he had a living trust, and he'd protected his estate with a living trust, and as a result, if you go down to the courthouse there in California where he was living, there's no record of who inherited all of that. So all of that was kept private. You know, we assume it went to his family, but we don't know. But the point is that he planned for it in a way that kept it out of the public eye, and also avoided a substantial expense and delay in having things administered. So anyway, those are my thoughts today about probate and how to avoid it.